Welcome to Lincoln's Inn. This is the fourth of a series of lectures in a collaboration between the Selden Society and the historical societies of each of the four Inns of Court. In the case of Lincoln's Inn, the Black Books Society. You either know about those or you don't, but I don't have time to explain if you don't. I have a very easy task this evening because both the subject matter of this lecture and the lecturer are much too well known to need really any introduction. Lord Mansfield and Lord Neuberger were both, in Lord Neuberger's case, are both in certain respects members, benchers and past treasurers of this inn. So they need no introduction within these walls. But more important than that, they were are both a colossus in their time of our legal system. I'm sure that Lord Neuberger will be politely shaking his head, but time will tell, and I have no doubt where I place my bet so far as that's concerned. So he's going to speak about Lord Mansfield, and I'm going to do little more than let him get on with it.
Mansfield, but thank you very much for the compliment. I'd like to start by saying what an honour it is to have been invited to deliver this annual Selden Society and Four Inns of Court lecture. It's an honour to follow in the footsteps of four former distinguished lecturers, the late and very much lamented Igor Judge, my former friend and colleague, the very much alive Brenda Hale, my friend and former colleague, Sir John Baker, from whose outstanding works on English legal history I've learnt so much, and Professor J. Tidmarsh, the renowned expert on civil litigation and procedure. But I turn now to my rather less contemporary, but at least equally influential subject, namely William Murray, later the first Earl of Mansfield. Given his enormous and lasting contribution to the common law some 250 years ago, and his own command and invocation of past legal practice and learning, I believe he's a very appropriate subject for a lecture in this series, which is aimed at demonstrating the importance of legal history in its broadest sense to the development and understanding of the common law. I'd also like to say how grateful I am to Dunstan Spate, the estimable librarian of Lincoln's Inn, for suggesting the subject and with providing me with so many thoughts and so much support. William Murray was born in 1705 at his ancestral home near Perth into a staunchly Jacobite family. Indeed, as a result of his support for the short-lived attempts of James II's son, James Stuart, the Old Pretender, to gain the throne from the newly installed George I in 1715, his father, Viscount Stormont, was to spend a year in an Edinburgh prison. The young William Murray attended at Perth Grammar School, where it appears that a combination of natural ability and good teaching ensured that he developed an early reputation for acute intelligence and great application, a reputation which he never lost. Maybe because they thought that his unusual intellectual abilities would be better developed south of the border, but maybe because they were disheartened by the political situation in Scotland, his parents arranged for William to finish his education in London. Accordingly, in 1719, he travelled on a pony on his own to London. In those days of poor roads and no trains, the trip apparently took him 7 weeks. And having left Scotland in this memorable way, he never returned and apparently never saw his parents again. His future career appears to have been the basis for Dr. Johnson's observation that much may be made of a Scotsman if caught young, and hence the title of this talk. Having arrived in London, Murray enrolled at Westminster School, possibly arranged by his father, because the Dean of Westminster was a strong supporter of the Stuart cause, so much so that a few years later he was exiled for leading a Jacobite plot. At any rate, by all reports, the young Murray continued to shine as an exceptionally hardworking and intelligent pupil. After 4 years at Westminster, he went up to Christ Church, Oxford. His rivalry with William Pitt the Elder, later Lord Chatham, appears to have originated from then, as Murray won a university competition for a Latin verse composition on the death of George I in 1727. He beat Pitt into second place, and Pitt appears never to have forgiven him. Murray may have won the prize with his poem, but 150 years later, another Lord Chief Justice, Lord Campbell, described his poem as a very wretched production. At some point while at Oxford, Murray decided that he wanted a career in the law. Given his relative impecuniosity, this seemed impossible, but his intelligence so impressed the father of one of his Oxford friends, Lord Foley, that he offered to fund Murray while he read for the bar. Murray joined Lincoln's Inn, where his commitment to serious study continued. He was trained in oratory by the poet Alexander Pope, and it's credibly reported that at that time Murray translated Cicero into English and back into Latin to improve his rhetorical style. At school, at university, and when reading for the bar, Murray was, as I've intimated, brilliant and hardworking. He was also seriously interested in history and jurisprudence. This is borne out by 4 letters he wrote in later life, which are in this inn's library, which were all addressed to those thinking of embarking on a legal career. 3 of those letters recommended respectively the study of ancient history, modern history, and English history, previous to entering upon the study of law. The width of Murray's own reading is apparent from these letters. To take one example, he suggested that the reader limits himself to only one work on the reign of King Louis XI of France to be studied, at least initially. But his advice also involved a light touch. For instance, he wrote, "Sometimes a single pamphlet will give us a better the clue of a transaction than a volume in folio." The 4th letter set out a recommended course of law studies, which initially concentrated on studying the law of nations, which is partly founded, he said, on the law of nature. And he was especially keen on the works of 2 17th century legal philosophers, Hugo Grotius and Samuel Pufendorf. Their influence on the future Chief Justice is plain. Grotius believed that everyone had a natural and legal right to acquire and retain assets. Pufendorf, no doubt with the memory of the horrendous 30 Years' War, was a strong advocate of freedom of religion and its protection by the law. But Murray also recommended more contemporary writers, including John Locke, who died the year before Murray was born, and whose writings exerted a great influence on Murray's generation, and on Murray in particular. The 4th letter also required an in-depth study of what Murray called municipal law, and in particular the domestic laws of England, Scotland, and France. He observed, "You will begin, of course, with Roman law, which included reading the text of Justinian's Institutes, and recommending they keep away from long comments, which would only confound you and make your head spin round." He then suggested moving on to an understanding of feudal law, without which, he said, it is impossible to understand modern history. The book he most particularly recommended was the now almost completely forgotten Giannoni's History of Naples, which he described as one of the ablest and most instructive books that ever was written. I've yet to test that, but I think it might be worth peu de voyage. Murray's emphasis on Roman law and civil law was out of step with the then current view of judges and lawyers generally, as he himself recognized. He wrote, "Civil law has long been rejected, both as a rule of government and of property," but added, "Yet so much good sense and such sound maxims of jurisprudence are conspicuous in the institutes of Justinian." Given that then as now, Scots law has strong elements of civil law, it is very likely that Murray's Scottish background was an important influence in his unfashionable taste for Roman law. Indeed, Holdsworth has emphasized the importance of Scots law to Mansfield's thinking throughout his career. Given the intensely pragmatic and practical approach which Mansfield adopted to the law when Chief Justice, the young Murray would presumably not have relished the then intensely insular nature of English law, with its obsessive concentration on archaic technical rules. And this was particularly as he was approaching it with the benefit of such wide and deep study of superior legal writings. After completing his legal studies, Murray spent much of 1730 traveling in mainland Europe, which included staying with his brother, a staunch Jacobite, undergoing self-imposed exile in Paris. It's apparent that at that time, and despite his subsequent denials, Murray was a Jacobite. In terms of circumstantial evidence, close family members were Jacobites, as were the teachers at Westminster, and the dons at Christchurch were notorious for their support of the Stuart cause. More specifically, and rather more recently, two surviving letters have been discovered, which Murray wrote to the Old Pretender's advisors, one of them specifically offering, quote, "my duty and loyalty to the king," thereby meaning the Old Pretender. But when in England, the ambitious Murray appears to have appreciated that any overt expression of Jacobite sympathy would be potentially career-destroying and to be avoided at all costs. Accordingly, while at Oxford, he'd made it clear that he supported the Hanoverian succession, and there are records to show that he proved a sad disappointment to the Jacobites at Oxford, given his family background. Indeed, it may well be that Murray's elegy on the death of George I, whose accession had precipitated the first Jacobite rebellion, that his elegy appears to have been at least in part prompted by his desire to distance himself from what may have been seen to be his treasonous background. On returning from his European journey, Murray was called to the bar and set up chambers at 5 King's Bench Walk. His first 2 years appear to have been pretty briefless, but his practice then developed rapidly. Much of it came from Scottish clients who gave him briefs in the House of Lords. He came to specialize in chancery work and was consulted on a number of boundary disputes, albeit at a rather grander state level than those two words conjure up today. A quarrel over a 6-inch wide strip across a suburban garage drive was not for William Murray. He was consulted on the location of boundaries, such as those between what would become the states of Maryland and Pennsylvania. He also had a success in cases which gathered some press coverage, including defending a man accused of adultery, or as it was then called, criminal conversation, with another man's wife, establishing by cross-examination that the husband had actually arranged the adulterous tryst. As his practice developed successfully, Murray was proving almost equally successful in investing his money, and he clearly enjoyed the style of life which money could buy. Some unkind people said it was keenness for money as well as social aspiration, which caused him to marry Elizabeth Finch in 1732. She was the granddaughter of the great 17th century judge, Lord Nottingham, the so-called father of modern equity. But it was, by all accounts, a very happy, if childless marriage, which lasted until she died 52 years later. And it's also clear that Murray's sense of propriety was greater than his enjoyment of money. When the temperamental Duchess of Marlborough sent him out of the blue the breathtaking sum, as it then was, of 1,000 guineas, simply as a retainer, he returned all but 5 guineas, which he said was his standard retainer. When she wanted his advice, the Duchess visited him without notice and would get angry if he was out, so that she had to wait for his return. On one occasion, she tired of waiting, and when Murray finally got back, his clerk told him that a woman had called who, as he put it, would not tell me her name, but she swore so dreadfully that I'm sure she must be a lady of quality. Murray appears to have been determined to succeed and confident of his ability. One of his biographies wrote that as a barrister, he does not appear to have had a moment of self-doubt. His determination and his success may have been in part due to his lonely journey from Scotland. There is evidence which indicates that those who lose a parent at a young age are more driven and consequently more successful. And in practice, Murray lost both his parents when he was 14. But above all, it was his outstanding intellect, judgment, and appetite for hard work, coupled with a facility for language, which ensured his success. However, in law and politics in the mid-18th century, who you knew and who you were could often be as important, even sometimes more important, than what you knew and what you were. As was memorably said, in the 18th century, patronage was power, and patronage scarcely bothered to wear a fig leaf. In that connection, a crucial event occurred in 1739, when a friend from his school days, Andrew Stone, introduced Murray to the Duke of Newcastle, who has been described as the most notorious distributor of patronage in British history. Shortly after he was introduced to Murray, the Duke instructed him to draft and negotiate some complex family arrangements to do with property and titles, and was very impressed with the result. Newcastle was effectively number 2 to the then Prime Minister, Robert Walpole, and on the latter's resignation in 1742, arguably became the most powerful man in government. He thought Murray would be an ideal person to speak for the government in the House of Commons. So in 1742, he arranged for Murray to be elected to one of his rotten boroughs. Murray made it clear that he was not prepared to be a mere backbencher, and he was appointed Solicitor General 2 days later. The following year, he became a bencher of this inn. The next 14 years saw the forensic intellectual Murray and the passionate, compelling Pitt effectively fighting it out from opposite sides in the Commons. The two of them were, and I quote, beyond comparison the best speakers, and you might hear a pin drop when either of them is speaking, according to Lord Chesterfield. But this was just part of Mansfield's working life, which involved arguing cases in court, normally for private clients in the Court of Chancery in the morning, giving the government legal advice in the middle of the day, appearing at the bar of the House of Lords in the early afternoon, defending policy in every area, including foreign policy, treaties, and war, and then speaking in the House of Commons in the late afternoon. And presumably, reading briefs, requests for advice, and government papers in the evenings. He also found time to give informal political advice on public issues to ministers and informal legal advice on personal issues also to ministers. His previous Jacobite sympathies must presumably have caused him some internal conflicts when in 1746, as Solicitor General, Murray was called upon to prosecute the leaders of the 1745 uprising seeking to replace King George II with the old pretender's son, Bonnie Prince Charlie, a venture which famously, of course, ended at Culloden. But Murray showed no signs of concern, and according to one source, he did his duty with firmness and moderation. However, a few years later, in 1753, Murray's career was threatened when the Recorder of Newcastle, Christopher Fawcett, apparently out of the blue, publicly accused Murray of having toasted the health of the old pretender some 20 years earlier. It's a measure how sensitive the Hanoverian monarchy was, and the government generally was, even in the 1750s, about a Stuart uprising, that this allegation was formally investigated by the cabinet, who exonerated Murray, as well as being debated in the House of Lords, in what I have to say reads like a fairly futile debate. In 1754, the Attorney General, Sir Dudley Ryder, became Chief Justice of the King's Bench Division, and Murray succeeded him as Attorney General. In that post, he was consulted by the Excise Commissioners, who wished to bring libel proceedings against Dr. Johnson. The proceedings were based on the definition of excise in his famous dictionary. Dr. Johnson's definition was that excise was a hateful tax leveled upon commodities and adjudged not by the common judges of property, but by wretches hired by those to whom excise is paid. Somewhat surprisingly by present standards, Murray advised that this was a libel, but more sensibly, he suggested that the author should be invited to change the definition. In the end, Johnson was apparently neither invited nor indicted. Murray was Attorney General for only 2 years because Ryder suddenly died in 1756, and Murray was appointed Chief Justice in his place. He insisted on a peerage as a condition of accepting the post, and initially unwilling George II was persuaded by the Duke of Newcastle to create Murray Baron Mansfield. His meteoric career via the Bar, Solicitor General, Attorney General, and Lord Chief Justice can be traced through the famous black books to which the Treasurer referred, which also record resolutions that his coat of arms be placed in the hall in 1757, and later on that prints of Lord Mansfield be purchased and framed. Lord Mansfield's time as Chief Justice was not only remarkable for his legal decisions, of which more anon, it was also remarkable for the way in which it involved a wholesale breach of the notion of separation of powers, which was supposed to exist in Britain and was admired by contemporary writers such as Montesquieu in France and Madison in America. In his first year as Chief Justice, Mansfield not only spoke on behalf of the government in House of Lords debates, he also had important roles as a member of the executive. Thus, very early on, he played an inglorious part in the House of Lords and behind the scenes in deterring George II from granting clemency to Admiral Byng, who had been court-martialed for losing Minorca to the Spanish and was consequently shot on the quarterdeck of his ship, famously, according to Voltaire, pour encourager les autres. Mansfield's part was inglorious because Byng was a useful but unfair scapegoat for the Duke of Newcastle, of whom Mansfield had been, of course, a protege, and the Duke was being blamed for not supplying Byng with reinforcements. Some 3 weeks after the wretched Byng was shot, the Chancellor of the Exchequer resigned. I don't think the two were connected. And the King appointed Mansfield to replace him, albeit only for 8 weeks. So in April 1757, within 6 months of becoming Chief Justice, Mansfield was also Chancellor of the Exchequer. At the end of that year, Mansfield became a member of the King's Cabinet, a body with some 20 members, which effectively ran the executive arm of government, and Mansfield remained a member for some 20 years. Over those decades, although busy most days in court, Mansfield frequently spoke for the government in the House of Lords. He attended many meetings with prime ministers and senior government ministers, and sometimes the King, discussing domestic and foreign policy issues and public appointments, both lay and clerical. More than once, he was offered the post of Lord Chancellor, but he preferred the Chief Justice's job, which, although significantly less well paid, did not depend on being in the government party and in favour with the Prime Minister of the day. A number of reports from different contemporaries consistently suggest that in the political world, Murray was despised for being timid in public on policy issues and a duplicitous maneuverer behind the scenes. But at the same time, he was admired, not infrequently by the same people, as an outstanding parliamentary orator and a wise and perceptive counsellor in private. His most recently and generally sympathetic biographer, Norman Poser, finds it, quote, difficult to disagree with an earlier description of Mansfield the politician as Machiavellian. His opportunism bitterly upset the Duke of Newcastle when he shamelessly deserted to the Marquis of Bute, when Bute was being favoured over Newcastle by the newly installed George III. But Mansfield's wisdom is illustrated by the fact that after a couple of years, the Duke reverted to seeking Mansfield's advice. Throughout his time as a law officer in the Commons and Chief Justice in the Lords, Mansfield was a keen supporter of the policy of the government of the day and maintained what Poser refers to as a steadfast devotion to the monarchy. His maiden speech after becoming Chief Justice was characteristic. It concerned the publication of a parody of the King's speech when opening Parliament in 1756. George II himself saw the funny side, saying that he hoped that the man's punishment will be of the mildest sort and that the spurious speech is better than the one I delivered. But addressing the House of Lords, Mansfield said the parodist should be imprisoned and that his spurious version of the King's speech should be, and I quote, burned in the palace yard by the common hangman for such an insult to the crown. On more significant issues, Mansfield was a keen supporter of a strongly aggressive military approach in the very successful 7 Years' War. 20 years later, he was even more vocal and firm in his support of the rather less successful American War of Independence, saying in one House of Lords speech, "If you do not kill them, they will kill you." The war started off well, and Mansfield felt that his support for the government should be rewarded by an earldom. When this was proposed to the king, George III replied, saying that Mansfield's zealous support for near 16 years seemed to entitle him very reasonably to ask the mark of favour that he did. And so an earldom was conferred, and as Mansfield was childless, his nephew, Viscount Stormont, was named as successor in the letters patent. The American War subsequently started to go wrong, of course, but despite this, Mansfield for a long time fought against all proposals to settle with the Americans. Britain's defeat in the American War effectively marked the end of Mansfield's political career, and he resigned from the cabinet in 1782. But the war produced an interesting sidelight on his character. When John Adams, later of course a US president, visited London in 1783 to negotiate the treaty which formally ended the war, he met Mansfield and, I quote, found more politeness and good humor than in Richmond, Camden, Burke, or Fox, all of whom had supported the Americans. There are conflicting reports of Mansfield's social manner. Boswell, who liked to visit him to rub shoulders, referred to Mansfield's cold reserve and sharpness, which he said was like being cut with a very, very cold instrument and chilling the most generous blood. But then he also wrote a bit later that describing Mansfield sitting with his tie wig, his coat buttoned, his legs pushed much before him, and his heels off the ground, and knocking frequently, but not hard against each other, and he talked neatly with vivacity. Mansfield's timidity, lack of personal loyalty, and unswerving support for the monarchy and government in the political sphere contrast sharply with his reputation for boldness and adherence to principle as a judge. A possible explanation arises from his early association with Jacobitism. While it appears that in his 20s Murray was a secret Jacobite, it is clear that over time he genuinely changed his allegiance to the Hanoverian monarchy. It may well be that his enthusiasm for the existing government was fueled by the zeal of a convert. Quite apart from that, his family and other associations with the Jacobite cause must have made him anxious to demonstrate his loyalty to George II and George III and their governments. In particular, the accusation and investigation in 1753 must have weighed with him, as must the fact that his Jacobite associations and supposed sympathies were invoked against him by his enemies throughout his career, often in scurrilous terms, and most famously by the anonymous, to this day anonymous, author of the published Letters of Junius. Turning now to Mansfield's judicial career, he was always on good terms with his judicial colleagues, over whom he presided, and who hardly ever dissented from his views, no doubt because he was such a formidable jurist, but also, I suspect, because he was such a strong character. He treated counsel who appeared before him firmly but fairly, although he was believed by some to favour barristers who had been to Westminster or Christchurch. He was keen to reduce the delays which were notorious, albeit he did not give judgment until he felt he had mastered all the details of the case. Although famed for his judgments, he may have had a somewhat equivocal attitude to judicial reasoning, if one story is to be believed. When asked by a young officer with no legal qualifications, who had been appointed governor to a Caribbean island, how he should adjudicate disputes, Mansfield apparently replied, "Tut, man, decide promptly, but never give your reasons. Your decisions may be right, but your reasons are sure to be wrong." At that time, of course, and for many decades afterwards, not just criminal cases, but many first-instance civil cases were tried with a jury. As Cecil Fifoot put it in his biography of Mansfield, the jury solved a particular problem. The judge rationalized the solution for future use. The jury revealed a fresh facet of human experience. The judge framed it in the general policy of the law. By insisting upon these complementary functions, Lord Mansfield maintained an equilibrium between stability and expansion, and determined the axis about which the mercantile world could resolve. Although I've referred to Mansfield's conduct in politics as contrasting with his judicial reputation, his record as a judge was in some respects consistent with his political stance. Thus, his rulings, directions, and sentences in criminal libel cases were very much in favor of the government and the crown. In 1758, he tried a Dr. Chabert, who had published letters criticizing government policy, and told the jury that this conduct approached high treason. When the jury found Chabert guilty, Mansfield sentenced him to stand in the pillory on 3 occasions and to be transported for 3 years. And in 1770, when the jury found one Henry Woodfall not guilty of seditious libel by publishing Junius's letters, Mansfield refused to accept the verdict and ordered a retrial. 4 years later, Woodfall was prosecuted before Mansfield for publishing a paper criticizing the Glorious Revolution and William and Mary, who had both died more than 70 years earlier. Having been directed by Mansfield in strong terms that criticism of a dead king could be libelous, the jury found Woodfall guilty of publishing the paper, but expressly refused to find him guilty of libel, even after being pressed by Mansfield to do so. Mansfield then took it on himself to hold that the jury must have found Woodfall guilty of libel, as they'd concluded that he published the paper, and he fined Woodfall heavily. One must, of course, be careful not to judge actions in former times by current standards, but it does seem as if Lord Mansfield was seen by many contemporaries as tending unacceptably to restrict freedom of expression. In somewhat similar vein, Mansfield could be a pretty harsh criminal judge, especially when it came to crimes which could undermine commerce. Thus, he invariably seems to have imposed the death penalty on forgers, and once went so far as to persuade the king not to pardon a forger who had pleaded guilty and had fully compensated his victim. An equal dislike of crimes that undermined the justice system led Mansfield to be a stiff sentencer of perjurers, and indeed he supported a bill which would have imposed capital punishment for perjury. While Mansfield was relatively unenlightened when it came to political freedom of expression and criminal sentencing, his judicial approach to women's rights and even more to religious freedom was very different. In a series of cases, he progressively widened the category of circumstances in which a married woman had the right to make contracts or to sue, deciding that the case law established a very limited circumstance, which he extended to any case, and I quote, where a woman has a separate estate and acts and receives credit as a femme sole. In contrast with his normal keenness to obtain convictions in criminal cases, Mansfield did his best to ensure that any prosecution of an alleged priest for saying mass would end with an acquittal. Thus, in one case, he took over the cross-examination of the main prosecution witness and warned the jury that you must not infer that the defendant is a priest because he said mass, and that he said mass because he is a priest. And he's added, if you bring in guilty, the punishment is very severe, a dreadful punishment indeed, nothing less than perpetual imprisonment. Unsurprisingly, the jury acquitted the defendant. And this was the case in 5 or 6 other cases of prosecution of alleged Catholic priests saying mass. Among fanatical Protestants, Mansfield was unpopular, with some even suggesting that he was a secret Jesuit. But he was equally disapproving of legislation which discriminated against dissenters. Indeed, he wrote of his desire to disturb no man for conscience's sake, and that he had always reprobated attempts to molest both Catholics and dissenters in the celebration of their religious worship as unworthy. Views differ as to whether the destruction of Mansfield's London house in 1780 by the Gordon rioters was instigated by his perceived pro-Catholic sympathies or by his severity in criminal and libel cases. The destruction extended to a library which included signed works by Jonathan Swift and Alexander Pope, and also to over 200 of Mansfield's judicial notebooks. The house was rented, and by then Mansfield had a country house which still survives at Kenwood, a lovely building and a lovely park, both thanks to Lord Mansfield, and a remarkable art collection, which has nothing to do with Lord Mansfield. Within a few days of having his house and possessions destroyed, Mansfield was back in the House of Lords, presiding over the proceedings with characteristic bravery, but also with characteristic pro-establishment approach. He stoutly justified the government's use of armed soldiers to quell the Gordon riot, although he said in the course of his speech, in light of the loss of his library, "I have not consulted books. Indeed, I have no books to consult." Given the present concerns about conflicts of interest, it's worthy of note that despite having been a victim of the riots, Mansfield had no compunction about presiding over the prosecutions of a number of those accused of responsibility for the riots. They included Lord George Gordon himself, who was acquitted of treason despite a characteristically pro-prosecution, uncharacteristically rambling summing up by Mansfield, who was frequently interrupted with corrections by Gordon himself, and which, in the course of his summing up, contained an extraordinarily wide definition of treason, which included an attempt to destroy all brothels. As I hope is clear, in his 32 years as Chief Justice, Mansfield presided over cases in almost every area of law. But his most lasting influence, indeed, in the legal world at least, his lasting fame, arose from his decisions in the field of commercial law. He was passionately committed to encouraging and facilitating commerce and protecting businessmen, and was highly suspicious of any laws which impeded business, or, as his attitude to forgers showed, any actions which threatened commerce. Thus, when Solicitor General, he opposed his own government's bill, which prohibited British entities from insuring enemy ships in wartime, and he would enthusiastically advise patent applications being granted. As a judge, he upheld the common law right to a perpetual copyright, despite a statute which limited it to a fixed period, and he was in due course overruled on this by Lord Camden and his colleagues in the Lords. It's tempting to think that Mansfield was influenced by his fellow Scot, Adam Smith, but that is unlikely, as The Wealth of Nations was only published in 1776. A much more likely influence on Mansfield in this connection was John Locke, whose famous second treatise on government, published in 1689, favoured free trade. Having said that, in Smith, Mansfield, and David Hume, Scotland produced three formidable 18th century supporters of commercial liberty. Mansfield was probably the single person most directly responsible for the assistance given by the legal system to the Industrial Revolution at home in the 18th and 19th centuries, and to the preeminence of the common law, and in particular English law, even today, in cross-border commerce. Like all great reformers, Mansfield was lucky with his timing. Great Britain's overseas trade mushroomed over the 18th century, with the biggest leap being between 1745 and 1765. And at home, industrialization took hold, thanks in terms of financing, to the long-term effect of the creation of the Bank of England in 1694. In practical terms, it was due to a plethora of inventions, including the separate condenser steam engine 1765 and the spinning jenny in 1764. And of course, another important factor was the canal building, which started in 1757. Commercial law at that time was devoid of coherent principles and did not take into account established market practice. Juries were generally simply told to decide the case on the basis of the individual circumstances of the case as they saw them, a recipe for uncertainty and impracticability. Mansfield appreciated this. He said in one case, and you can find it in a number of other cases to the same effect, that the great object in every branch of law, but especially in mercantile law, is certainty, and that the grounds of decision should be precisely known. This fundamentally important principle has been echoed ever since in judgments given by highly distinguished judges, and indeed by less distinguished judges. Accordingly, Mansfield set about developing a coherent set of principles of commercial law as appropriate cases came before him. He frequently imported into English law principles from the lex mercatoria, or law merchant, the law developed by the major Italian states, which then spread throughout Europe. And if that did not provide an answer, he looked to Roman civil law and other sources which he had devoured in his youth, including the works of Pufendorf and Grotius. As Holdsworth noted, some lawyers had already recognized that the legal principles underlying these commercial customs could be learned only from the writings of foreign civilians. But, he added, it was not until the common law obtained in Lord Mansfield, a judge who was master of this learning, that the rules deducible from the many various commercial customs which had come before the courts were formed into a coherent system and completely incorporated with the common law. Consistent with this, a more practical aspect of Mansfield's judicial approach was to adopt the system of special juries to commercial cases. He would assemble a body of men experienced in the relevant business to help decide the outcome of such cases. Contrary to our ideas of the judge-jury relationship, but perhaps not so different from the approach to jurats in the Channel Islands, Mansfield would not only discuss the case with the jury, but would sometimes do so privately, even over dinner at his home. Another feature of Lord Mansfield's thinking was to import ideas of morality and equity into common law. As the editor of Mansfield's papers, James Oldham, put it, he also strove, though a common law judge, to reach equitable solutions in cases that he tried, as long as he could do so without upsetting established legal principles or without offense to a higher value. And Oldham adds that in that he anticipated the eventual merger of law and equity. Whether Christian belief played a part in Mansfield's thinking is far from clear. He was a professing member of the Church of England, attending church every Sunday, but said nothing about his religious beliefs, and he did not expressly bring Christian principles into his judgments. Of his many contributions to commercial law, indeed to the common law generally, quite a few stand out as exceptional, even by his high standards. In the fourth year of his judicial career, he decided Moses and McFarlane, which was described by the late Peter Birks as the leading case in the Anglo-American law of restitution or unjust enrichment. And in a 2015 UK Supreme Court case, it was described as the cornerstone of common law restitution by Lord Mance. Mansfield simplified and clarified the law on bills of exchange and other bills used as negotiable instruments. In Miller and Race, he held that a promissory note was not like other assets, and so a bona fide holder in due course, or as Mansfield put it, in the course of currency and in the way of his business of the note, acquired ownership even if his seller did not have good title. He justified this, what some regarded as revolutionary decision, by the fact that if a bona fide holder of a note could not rely on his ownership, it would stop their currency. Mansfield also effectively rewrote, simplified, and can almost be said to have codified the law of insurance, paving the way for London to become the center of the 19th and 20th century global insurance industry. Although referred to in statutes, the important concept of insurable interest was neither understood nor defined until Mansfield explained and developed the term. And even more importantly, in Carter and Burm, he established the now very familiar principle of ubere mai fidei, utmost good faith, in insurance contracts. And he also laid down the principle that an insurer was deemed to know the usual risks which accompany a particular adventure. As early as 1787, while he was still alive and had recently retired, Mansfield was described in a judgment as the person who it may truly be said to be the founder of the commercial law of this country. And more recently, 50 years ago, it was authoritatively said to be due to Lord Mansfield's genius that the harmonization of commercial custom and the common law was carried out with an almost complete understanding of the requirements of the commercial community. Of course, he didn't have it all his own way. In Pillans and Van Meerop, he rejected the concept of consideration in contract following the civil law and was put down after 13 years. That decision was overruled by the House of Lords 13 years later. It's fair to say that there is a view that, as it was put by Professor Brown Simpson, the late Professor Simpson, Mansfield was no innovator in legal matters, and his ideas commonly involved no more than a bold and striking affirmation of views expressed by others. I rather suspect that all this really means is that Mansfield's contribution to the common law were not made in a vacuum, but represented developments and syntheses of previous judgments and writings. But that's precisely what one would expect of a common law judge, and it is indeed reflected by Mansfield's frequent citation of and respect for previous judicial decisions, at least when they established what he regarded as a rational principle. I suggest that, if anything, this reinforces rather than undermines Mansfield's achievements. Mansfield's passionate belief that the law should not interfere with property or freedom to trade clashed heavily with his humanity and moral beliefs when it came to what is, at any rate to non-lawyers, his most famous decision, namely in the Somerset case. In the late 17th century, there were conflicting judicial dicta as to whether slavery was recognized in English law. That uncertainty persisted into the 18th century. There was an opinion in 1729 from both law officers that a slavery contract would be recognized and enforced by an English court. But on the other hand, the first edition of Blackstone's famous commentaries in 1765 took a different view, although the second edition a year later qualified this so as to make the position incomprehensible. Our disgust and abhorrence of slavery makes it impossible fully to understand how anyone, let alone an otherwise civilized, educated person, could have had any truck with, let alone supported, slavery in the Age of Enlightenment. But the slave trade and the use of slaves in transatlantic sugar and tobacco plantations contributed very substantially to British prosperity and to the wealth of many of the country's most influential citizens. And it's extraordinarily easy for us human beings to equate what is in our interest with what is morally right, or at least with what is not morally wrong. Having said that, even in the 17th century, it's fair to say that there were many impressive people who spoke and wrote against slavery. They included John Locke, who had written in 1690 that slavery is so vile and miserable an estate of man, and so directly opposite to the generous temper and courage of our nation, that it's hardly to be conceived that an Englishman, much less a gentleman, should plead for it. And Locke, of course, was a strong influence on Mansfield. Although a few cases involving slaves had come before Mansfield in the 1750s and 1760s, none of them required him to face up to the question of whether slavery was lawful in England. And then in 1769, an application for habeas corpus was made on behalf of James Somerset, whose master, Charles Stuart, had brought him from Boston, Massachusetts, to England. When Somerset had escaped, Stuart had him apprehended and placed on board a ship with a view to sending him to Jamaica to be sold. Somerset was fortunate enough to have abolitionist godparents who heard about this and made the habeas corpus application to Mansfield. Mansfield ordered the ship's captain to appear before him to see whether he could justify holding Somerset against his will. It's clear that Mansfield was keen to avoid having to decide the case. He uncharacteristically failed to push the parties along for a hearing and granted adjournments almost every time they were sought, even when they were for flimsy reasons. One could, I suppose, charitably suggest that he adopted a 21st century approach by trying to mediate a settlement. He told the parties that he'd managed to persuade other parties in 6 previous such cases to settle, and more than once he unsuccessfully encouraged the godparents to purchase Somerset from Stuart, and more than once unsuccessfully encouraged Stuart to grant Somerset his freedom. But each of the parties were being financed by abolitionists on one side and plantation owners on the other, and both groups wanted a decision. Eventually, the case came on for hearing. At the end of the argument, Lord Mansfield indicated that judgment would be reserved, while strongly recommending that the case be accommodated by the parties. He added that if the parties will have judgment, fiat justitia ruat coelum, let justice be done, whatever the consequence, and went on to emphasize that compassion will not on the one hand, nor convenience on the other, be to decide, but the law. 5 weeks later, Lord Mansfield gave a short judgment, which, according to what is probably the most reliable contemporary record, concluded by saying, "Slavery is so odious that it must be construed strictly. No master was ever allowed here to send his servant abroad because he absented himself from his service or for any other cause. No authority can be found for it in the laws of this country. And therefore," as he was speaking on behalf of his colleagues as well, "we are all of the opinion that James Somerset must be discharged." A more eloquent version of wider scope can be found in Loft's report, but Capel Loft, also of Lincoln's Inn, was a keen abolitionist, and one suspects that he was anxious to make Mansfield's words have as wide an appeal as possible. The decision in Somerset was seen as significant at the time, but it did not have as great an effect as one might have expected. The notion that Mansfield himself regarded the decision as having a relatively narrow scope is supported by an interjection which he is recorded as making during legal argument in a later case, when he said that Somerset and other cases go no further than that the master cannot by force compel the slave to go out of the kingdom. A case which he decided more than a decade later, Gregson and Gilbert, does Mansfield no credit in modern eyes. The Zong, a ship carrying hundreds of slaves from West Africa to Jamaica, got lost and ran short of water. 60 slaves died of thirst, 40 slaves threw themselves overboard, and 150 were thrown overboard. The ship owner sought damages for the loss of the slaves from his insurer, and the jury awarded the ship owner damages. On appeal, Mansfield and his colleagues ordered a retrial because, quote, "there was no evidence of the ship being foul and leaky, and there was no evidence of necessity to throw any slaves overboard." Mansfield, for whom morality was such an important ingredient in commercial law, did not even suggest that there was anything fundamentally questionable about this appalling claim. In his private life, as a recent well-received feature film recorded, Mansfield and his wife took in Dido, the illegitimate daughter of his nephew and a black slave in the West Indies. Poser describes Dido as having had an intermediate status at Kenwood, being neither a full member of the family nor a servant. Mansfield left her £500 in his will, in which, perhaps because he was unsure whether slavery existed in England, he also confirmed her freedom. Just to complete her story, she married after his death and had 3 children. During the first half of the 1980s, when Mansfield was getting into his 80s, Mansfield was still spry. But in 1786, a year after his 80th birthday, and 2 years after his wife had died, Mansfield stopped sitting in court, although he continued as Chief Justice for another 2 years. After retiring in 1788, he enjoyed 5 years' relaxation in Kenwood, being looked after by various unmarried female relatives, including Dido, and he took a keen interest in politics, especially in the French Revolution. He died peacefully and in full possession of his remarkable faculties on the 17th of March, 1793. Like all judges, Mansfield was a creature of his time, his heredity, and his upbringing. Like almost all judges, Mansfield was not always entirely consistent in his jurisprudence. Like many judges, Mansfield was devoted to the law. Like a few judges, his judgments are regularly referred to long after his death. However, where he stands out is in his contributions to the development of the common law. He probably stands out as one of the most, arguably the most impressive English judge of all time. For a modern comparison, he had much in common with Lord Denning, also a Lincoln's Inn member, whose judicial tenure was even longer than that of Lord Mansfield. They were both brilliant legal scholars and outstanding judges, whose deep knowledge and love of the law, especially the common law, was combined with and occasionally overwhelmed by a strong moral and modernizing drive. Lord Denning was more generally popular with the public and was described by Lord Bingham, another great judge, as the best known and best loved judge in our history. Whereas no doubt partly because of his political involvement, Lord Mansfield's public standing was more controversial. Their moral and modernizing approach meant that their decisions were often controversial with legal scholars and some fellow judges. Lord Denning often did not see eye to eye with the much more conservative Lord Chancellor Viscount Symonds, and Lord Mansfield's judicial approach was very different from that of the much more traditional Lord Chancellor Lord Camden. Yet, while they were both generally progressive in developing the law, Lord Denning and Lord Mansfield were both politically conservative, and this meant that their decisions in some areas of law were reaction rather than progressive. Such considerations serve to remind us that judges cannot leave their principles wholly out of account when sitting on the bench. An important quality of a good judge is not merely to have sound principles, but to take into account those principles in appropriate circumstances and to an appropriate extent. As with all other measures of good judging, Lord Mansfield generally scored very highly on that measure. With legal giants like Lord Mansfield and Lord Denning, it's unsurprising the reputation of English law and English lawyers has been so high across the world. Thank you all.
Lord Neuberger very kindly told me before he started that he would be prepared to take questions. I said I might take him up on that if he fell short of his full hour's commitment to us. Well, he has done by about 2 minutes, and therefore, are there just 2 questions which 2 people would like to ask? You may be let off.
There's somebody at the top.
No, there we go.
There's somebody there too.
There's a microphone up the top.
Oh, thanks very much. I'm Scott Ireland, speaking of Scott. I was reading an article by David Panic an hour ago, which was written 40 years ago, which must have meant that he wrote it as a teenager. And he mentioned that in Mansfield's 32 years, that only 20 of his judgments were non-unanimous, which meant that as well as being irreverent and persuasive, that he was also a free thinker. And we know that he was a free thinker in the way that Denning and Kames in Scotland and I guess Robert Gough was in England, who's another son of Persia. Given that judges are under some scrutiny from friends in Tufton Street and elsewhere in the UK, how do you think that Mansfield would have been viewed by friends in Tufton Street today?
I think it's very difficult to answer that because translating it to modern times, he couldn't have been a politician, and yet a lot of his reputation was political, based on it was politics. And I think that the other point, of course, is that he would have been hated generally by the press because he was probably, apart from slavery, where he was a bit equivocal, man of his time, it's fair to say, but on freedom of the press, in terms of political freedom of expression, he was definitely not on the enlightened side. It may have been being more Hanoverian than the government because of his Stuart connections. It may have been his political inclination. But I think, I mean, look, Lord Denning managed, in a sense, to get away with his pretty conservative views on students and trade unions and so on. But that, one suspects, is because the press was, a lot of the press was rather in agreement with him. But when it comes to freedom of the press and freedom of expression, the press tends to take a rather different view.
One more very short one.
Thank you very much for a really interesting lecture. I just had one question about the developments of equity and Lord Mansfield's sense of morality. How did that square in the commercial cases for you with this need for certainty? I just wondered if you could reflect on that at all, please.
I think that highlights a problem that exists for all judges, particularly in the common law system, trying to balance certainty and fairness, certainty and honesty, and so on. And I think that, for instance, I think his concern about honesty is what drove him in part to wanting to get rid of consideration. If you made a promise, you should keep to it. And I could have said that was rather foreshadowing Denning with his keenness on estoppel to get round problems such as consideration. Although you could say estoppel inherently involves consideration because you have to act. But I think that if you start analyzing judges carefully, there are conflicts in their approach because they're engaged in human activity and judging human actions, and there is an element of inconsistency or right. And in the end, you're balancing. The balancing argument is always a bit of a get out of jail free card because it is ultimately a bit subjective, and that's when you get away from certainty. So it's a slightly confusing answer because I think it's a confused area where judges are a bit confused. We like to boast about the certainty and the pragmatism of common law, and the two, almost by definition, do knock against each other.
Sorry about the litter.
If I can introduce myself, my name is Lord Cryan, and I'm the president of the Selden Society. It's my tremendous pleasure to thank Lord Neuberger for an absolutely enthralling talk. And I happen to know that he did even more work than is apparent from the excellent talk which he has delivered to us this evening. It will be available in printed form on the Selden Society website, and I imagine on the Lincoln's Inn website as well. So so his work will not be wasted, and it's well worth a read. I've had the benefit of being able to see the extended version of it, and I commend it to you when it's available. In addition to that, there will be the video recording of this talk, which will also be available on the Lincoln's Inn website and indeed on the Selden Society website. It is difficult for me to sum up how grateful we all are for somebody as busy as Lord Neuberger to have taken time out to put in the labour that he has done, and quite obviously has done, to produce this stellar talk. And so thank you very much, David. It's very, very good of you to have done that. The next thanks I must give is to Lincoln's Inn. Master Treasurer, thank you for Lincoln's Inn for hosting this. In fact, it's the fifth in the series, but it's a little bit confusing because the first one was in COVID, which was online. So we've been going round the inns since then, and we've come here at a time which is very apt because your wonderful lecture theatre is still relatively new and absolutely jam-packed as it should be for such an important event as this. But what a facility to have, and Lincoln's Inn should be, if I might say so, very proud to have taken the gamble of putting together such an expensive but brilliant facility. So thank you very much for that. The final thing I want to mention is the Selden Society's talk next year, with the Selden Society's Four Inns talk. The precise date and speaker have not yet been absolutely finalized, though very nearly. And they'll be publicized through the history societies of the Four Inns and the Black Book Society here, obviously, and the Selden Society. If it's going to be, though I think it is, I think we should all find it a very stimulating evening. And please look forward to it and come when the details are finally published. The final thing I want to say is this. The Selden Society has, over the last 10 years, produced rather more of its annual volumes than it has needed. And we have quite a stock of them available. If any member of the society or anybody wishing to join the society would care to go on to the website, they would be welcome to have the back number volumes at only the cost of postage. And so look on the website or talk to the secretary who's here this evening, who will tell you how to go about things. But thank you again for coming. And again, thank you to our speaker, and thank you to Lincoln's Inn for hosting us.